Major breaking news as the United States Supreme Court has just decided a huge win for the Republican Party and effectively for the Second Amendment because of the methodology they used in ruling in favor of the National Republican Senatorial Committee over the federal government. There's a lot to learn here for the Second Amendment community, and this is a big win for the Republican Party, which frankly we need to succeed if you want to keep the House and the Senate this November. And we do, because if the Democrats get in there, they're going to pass gun control laws. You know it, I know it, and we're going to break it all down when we come back. Good news out of the U.S. Supreme Court. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 and 2026 Gundies Awards. All right, folks, so we have a big win out of the U.S. Supreme Court. I know this was just a week or so ago, but I'm getting to it now because I've had a lot of Fox News appearances, as you know, for those of you who catch me on TV, but we're catching up. But this is a big deal, folks. And remember, the reason why you watch the Four Boxes Diner is to learn about other areas of the law and how these other areas of the law, these other decisions outside of the context of the Second Amendment, can turn around and help us win for the Second Amendment. And that is the case in this decision by the United States Supreme Court in the National Republican Senatorial Committee against the FEC, the federal government, the Federal Election Commission. And there's a lot of good stuff here. In fact, it even speaks a little bit to the National Firearms Act. We'll get to that in one moment. But to begin with, let me tell you what this case is about. Let me tell you what the result was. And then let me tell you all the good reasons why this is very exciting and excellent news for the Second Amendment. To begin with, this is a case involving the First Amendment. As you know, among other things, the First Amendment says you have a right to free speech and that Congress can make no law abridging the freedom of speech. That is the case. It has been the case since the year of our Lord, 1791. Now, after Watergate in the 1970s, Congress passed these federal laws that started to restrict the spending of money on elections in various ways. One of the things they did is they said that if you are a political party, like you're the Republican Party, you're the Republican National Committee, you're the National Republican Senatorial Committee, if you're a political party, political committee, any of those things, Congress says you're not allowed to communicate with in a robust way and coordinate your strategy for spending money on campaigns with political candidates themselves. Now, this had the effect of tremendously helping the Democrats out. Why? Because the Democrats have a lot more money spent by independent organizations and sort of non-political entities, these NGOs, some of which were funded by the USAID. You remember that from the Doge era last year and everything else. So the Republican Party was at a strategic disadvantage because the Republican Party raised a lot more money than the Democratic Party. But because of this congressional law passed, of course, by basically anti-American Democrats in the 1970s in Congress, they basically thwarted the ability of the RNC and the Republicans to spend money in coordination with a particular political candidate. This was tremendously great for the Democrats and very harmful for the Republicans. And just if I can pause for one moment and put this into context today, in July 2026, just to show you the reason why this is a huge decision that this law got knocked out by the Supreme Court on First Amendment grounds is as we sit here today, the RNC, the Republican Party today has somewhere around $125 million in cash on hand, and they have no debt. In contrast, today in July 2026, the Democratic National Committee, the DNC, has about $15 million cash on hand, and they have $18 million in debt. So when it comes to the financial health of the Republican Party versus the Democratic Party, the Republican Party is much healthier. But here's the thing. Up until this decision by the U.S. Supreme Court that knocked out this ridiculous law on First Amendment grounds, it was just decided in an opinion by Justice Kavanaugh, 6-3. The case name is the National Republican Senatorial Committee versus the FEC. Up until this Supreme Court decision, the Republican Party, despite having $125 million in cash on hand, they were not legally allowed to coordinate with like a candidate for a House of Representatives seat. They could not coordinate their spending with a Senate candidate. So, for example, hypothetically, if you're Brandon Herrera and you want to be able to talk to the RNC and coordinate your ad campaign on YouTube, an ad campaign locally, and a newspaper campaign, right? You could not coordinate. So up until this decision, Brandon Herrera would have to, or any other candidate for office, for federal office, would have to do their own thing. They'd have to, raise their own money, spend their own money, do their own thing. And if they had particular goals in mind, like, geez, if I had another $5 million to focus on, like, the Second Amendment community in newspaper ads in Southern Texas, whatever it is, that communication could not be made to the RNC and say, geez, RNC, I would like to coordinate. We, the campaign, would like to spend money on YouTube. We would like you to spend your money to help me out in newspaper ads or whatever it is. That kind of discussion, that kind of coordination under the federal law was not allowed to occur. So because under that federal statute that was not allowed to occur, the Republican Party sued with J.D. Vance in the lead here as a Senate candidate. He sued and says that this law that prevents the coordination of political parties with political candidates is crazy and clearly violates the First Amendment. And I'm happy to report the Supreme Court 6-3 absolutely agreed with this. So let me tell you what Justice Kavanaugh wrote to explain the issue, and then I'm going to read to you why he thought this is crazy and why it's appropriate for there to be coordination between political parties and outside organizations and candidates and why it all makes sense. And then after that, I'm going to point out to you the great language that we in the Second Amendment community are going to be able to use to advance the right to keep and bear arms in court. So to begin with, here's Justice Kavanaugh explaining what this case is about and why it's important. Check it out. Ratified in 1791, the First Amendment provides that Congress shall make no law abridging the freedom of speech. As relevant here, the Federal Election Campaign Act limits a political party's campaign spending. Those spending limits necessarily abridge political parties' freedom of speech. Because virtually every means of communicating ideas in today's mass society requires the expenditure of money, a restriction on the amount of money a person or group can spend on political communication during a campaign necessarily reduces the quantity of expression by restricting the number of issues discussed, the depth of their exploration, and the size of the audience reached. So there's Justice Kavanaugh kind of laying out the issue. That you need money to run campaigns. You need money to get your ideas out there. That's the point. And it's appropriate for political parties to raise money for their candidates and for political candidates to raise money for themselves. And there should be coordination there, because why wouldn't there be? It's a violation to prevent people from talking and coordinating. That's, of course, what the Supreme Court just said. But here's what Justice Kavanaugh had to say talking about this particular case. Check it out. Applying the First Amendment, this Supreme Court has long ruled that a political party possesses a right to make unlimited independent expenditures during a campaign. That is, expenditures without coordinating with a candidate. But the federal law being challenged still limits a political party's coordinated expenditures. As the name implies, a political party's coordinated expenditures are the party's expenditures on, for example, advertisements produced or distributed in consultation with a candidate's campaign. And Justice Kavanaugh goes on to point out that the importance to political parties of the ability to coordinate with candidates, because again, political parties can only succeed and their policy preferences, like for example, their support of the Second Amendment right to keep and bear arms, can only succeed if their candidates win. Again, if you think about a big picture, if Donald Trump had not won in 2016, and yes, as you know, I was on the presidential transition team for President Trump, and a media surrogate for President Trump in 2016, had we not prevailed in 2016, we would not have Justice Gorsuch on the Supreme Court. We would not have Justice Barrett. We would not have Justice Kavanaugh. We would have 3 liberals on the Supreme Court, and I can assure you the Second Amendment right to keep and bear arms would be not protected today. Beyond that, of course, who knows what kind of laws would have been enacted against guns had Donald Trump not won that election. And of course, we know that's the same for the Senate and the House, because if the Senate is not controlled by Republicans, that means conservative justices on the Supreme Court, conservative judges on the lower courts, they won't get confirmed. So it's a really big deal to win elections, and obviously we all know this. So here's what Justice Kavanaugh has to say explaining exactly that. Check it out. Here concerns federal limits on spending by political parties in coordination with candidates. For example, a political party may spend money to produce and place a television advertisement in support of a candidate after consulting with a candidate's campaign about the content, timing, or placement of the advertisement. And of course, political parties articulate policy positions and platforms like the right to bear arms. select candidates through a primary or caucus process, and then support the election of those candidates in general election campaigns. Because a political party's success or failure on things like the right to keep and bear arms, depends in large part on whether its candidates get elected, it is natural for a party and its candidate to work together and consult with one another during the course of an election. So that's the issue. And the Supreme Court said that the federal law that prevented political parties like the RNC from spending their $125 million in coordination and cooperation with particular candidates, that law passed by Congress after Watergate is unconstitutional under the First Amendment. That is very good for the Second Amendment because it's now going to open up the ability of the Republican Party to compete with these NGO independent expenditures of the Democrats. And we know which side the Democrats were on in this issue because the Democratic Party, the Democrats all came out in support of these campaign limits. That's right. In this case before the Supreme Court, it was the Republican Party that was defending the First Amendment right to free speech. The Democrats came out and opposed it. They want restrictions. They want restrictions on this kind of coordination because they have a lot more billionaires that are politically active that can set up these organizations that can then spend money to advance the Democratic cause. And that's why the Republican Party historically has relied on small donors to give money to the party and whatnot in these groups, but they couldn't coordinate with the candidates, which made it harder for Republican candidates to win elections. And that's why it was the Republican Party that brought this case that vindicated the First Amendment right to free speech, and the Democrats opposed it. And I should also note, this is very good news, that the Trump DOJ did not defend this federal law. They said, we think the law violates the First Amendment, and amicus was appointed by the Supreme Court to argue in favor of the law, and I'm happy to report that the amicus lost. But the point is that this sets yet another precedent that we've talked about on this channel, that if the Trump administration chooses not to defend a federal law, I don't know, let's say parts of the National Firearms Act, that has been done by the Trump DOJ because they just did it here in the National Republican Senatorial Committee case before the Supreme Court. They refused to defend the federal law, and amicus was appointed to defend the law, and the Supreme Court ruled against the law, which is exactly what we want in the Second Amendment community. Now, with that said, there's also very favorable language here about the importance of text and history, and wherever there's a restriction on speech, i.e. the right to keep and bear arms, the burden is on the government to somehow justify it. So this is the kind of language that you will be able to cite to in Second Amendment arguments in favor of the Second Amendment, relying upon the Supreme Court precedent. While they're talking about the First Amendment, they're talking about the Bill of Rights and how the burden is on the government to justify restrictions on any of these kinds of rights, which is exactly what they said in Bruin, by the way. Anyway, here's what Justice Kavanaugh and the 6 justices had to say about text and history and the burden on the government to justify any kind of restriction on constitutional rights. Check it out. We begin with the First Amendment fundamentals. The text of the First Amendment provides that Congress shall make no law abridging the freedom of speech. The First Amendment embodies a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. As a matter of text and history, therefore, the restriction on political party coordinated expenditures would appear to violate the First Amendment. Goes on to say that this Supreme Court's precedents start with a basic precept that, listen carefully, folks, that when the government restricts speech, the government bears the burden of proving the constitutionality of its actions. Restrictions on campaign expenditures for political speech are permitted only in the exceedingly rare circumstances where they promote a compelling interest and are the least restrictive means to further the articulated interest. By the way, remember how I told you that the First Amendment jurisprudence has problems because they embraced for decades this tiers of scrutiny, which basically says that even when the government violates the First Amendment right to free speech, they can still win the case if they show a super compelling reason for doing so. So in this particular case, Justice Kavanaugh and the court wrote in the National Republican Senatorial Committee decision that, yes, not only did these federal restrictions restrict the right to free speech, but there was no compelling state interest to justify it, and therefore this federal law goes by the wayside. But in the context of the Second Amendment, it's even better for us because, as I've explained, the tiers of scrutiny has been destroyed and won't be applied, unlike the First Amendment context, because they had to embrace the barnacles of past precedents. But we don't have those barnacles in the Second Amendment context, and that is very good because once it is determined that the right to keep and bear arms has been infringed, that's it. There is no compelling interest. There's no balancing of interest. There's no tiers of scrutiny. None of that nonsense we see in the First Amendment area exists in the Second Amendment area. And here you can see where Justice Kavanaugh is saying that when you look at text and history, there's clearly a violation of the First Amendment here by this particular law, and the burden is then on the government. And then he goes on to say, because it's the First Amendment context, they have a chance to show a compelling state interest to justify the restriction, which they cannot do, and therefore the law goes away. But if it was a Second Amendment case, once they say the burden is, once they say there's a restriction on the right to keep and bear arms and it's an infringement, you don't have to continue on to ask the government, do you have a compelling reason for doing this? Because that extra bite of the apple is unavailable in the context of Second Amendment jurisprudence, unlike in the case of First Amendment jurisprudence. But here it did not matter. The Republican Party won. This is great news for keeping the Senate and for keeping the House this fall, because again, the Republican Party has a lot more money than the Democratic Party, but up until now, they could not spend that money in coordination with particular political candidates, which they should always been allowed to do, because to deny that ability was really a violation of the First Amendment. And I'm happy to say the Supreme Court just did this, which is very good news for the Republican Party and very bad news for the Democrats. This is why the Democrats came out and fought against the First Amendment and fought for this federal law, but the Supreme Court rejected the arguments of the Democratic Party in this case of National Republican Senatorial Committee versus the FEC. All right, folks, hope this wasn't too geeky. I appreciate you tuning in. Make sure you follow me on X at 4 Boxes Diner. Don't forget to subscribe both to YouTube and to Roman. I'll talk to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.